Welcome to one of the most emotionally charged hearings you'll ever witness. What starts as a procedural argument quickly unravels into a clash about respect, gender bias, and courtroom ethics. The prosecutor accuses defense counsel of treating her differently, not for her arguments but for being a woman. The judge steps in, unimpressed with the defense's tone. But here's the twist. Beneath the personal tension lies a complex legal question. How far does Michigan's rape shield law go at a preliminary examination? Does it protect victims before trial or only at trial itself? Stay tuned, because by the end of this session, we'll see sharp legal minds collide, reputations questioned, and one judge forced to draw a hard line.
My male colleagues from our office would have been treated the way I've been treated by defense counsel.
Court does call the case of the people, state of Michigan versus Cyrus Abadi.
Good afternoon, Your Honor. Marie Tan, Assistant District Attorney.
And good afternoon, Your Honor. With all on behalf of Cyrus Abadi, standing to me, right? Cyrus, please speak.
Good afternoon, Your Honor. Cyrus Abadi here.
All right, this has come back to me. I don't know if it's really a motion, but I don't know who would like to start, but I certainly have some questions.
I have a few things to put on the record, but I'll defer to Mr. Dowse if he wants to go first. I have no problem with that.
I do not need to go first. So.
Well, you might need to. I'm going to let you put on what you need to put on the record, because I think the last communication I saw, Mr. Dowse had filed something and you had requested whether or not we needed a written response or whether or not you could give an oral response. I think my staff had indicated what my answer was and that you could give an oral response on the record. So if that's where you'd like to start, go ahead.
That's correct, Your Honor, and thank you for the opportunity to do so. I actually don't know where to start. This is a unique situation. I've never been accused in a public filing of lying. I've never been told that my narrative is sanctionable. So I'm not sure exactly where to start. I will start.
Well, I've got some things to say about that, but go ahead. Because and Mr. Dawes, I'm just going to tell you, I don't expect attorneys to necessarily like each other. I don't even care whether they like each other.
Already we can feel the tension rising. Notice how the prosecutor immediately calls out gender bias before even touching the case facts. That's unusual. Lawyers typically avoid accusing opposing counsel of sexism on the record. But she's clearly hit a limit. And watch how the judge handles it. Calm, procedural, but you can tell he's measuring every word. For viewers, this moment sets the stage. This isn't just about a defendant named Cyrus Abadi. It's about professional respect and the invisible power dynamics in the courtroom. Question for you. Do you think she was right to call it out publicly, or should she have handled it privately?
To each other is irrelevant to me unless they cannot communicate in some professional way. But as I've told other attorneys, and particularly, and I'll name him Mr. Bennett, when he came and he accused somebody of some type of misconduct, that when that statement is made, the court has to look at that. And so I made it very clear to him, and I'll make it clear to you. If those are the kinds of things that are going to happen, you better be ready to roll with it, and you better have it. Because if you don't, that's sanction. Ms. Tanner, you may proceed.
Your Honor, as counsel knows, and I think everyone in this room is aware, within this profession, our reputation and our integrity is everything. Throughout my career, I've routinely made decisions that were difficult decisions to make in a lot of aspects. I've been able to make those decisions because my reputation and my integrity are that important to me. Quite frankly, no case is worth me losing.
Here, the prosecutor's speech about reputation and integrity is textbook legal ethics. She's reminding everyone, including the judge, that credibility is currency in the courtroom. Losing it is career death. But there's another layer. She's framing herself as a professional who defends others, implying the defense crossed a sacred line. That's rhetorical strategy. She's not just defending herself, she's setting a moral contrast. Every sentence tightens the emotional screws, and the judge knows it. What's interesting is how she's turning a gender issue into a professionalism issue, which makes her argument harder to dismiss.
everything I've worked so hard for. What I've also routinely done in front of Your Honor, as well as other judges, is stand up here and make a point of defending opposing counsels when other people have accused them of anything from lying to misconduct and so on. The reason I make a point of doing that, even though in many situations that has truly not been necessary, is because I want to be very clear how important it is that we don't throw out baseless accusations at people. It's not a new situation to me necessarily to encounter a situation with opposing counsel where we disagree, where we misunderstand each other. I don't take offense. I've gone head to head with some of the best attorneys in this county as well as other counties. And not once have I been accused of what defense counsel is accusing me of. And what bothers me more is I actually started out respecting defense counsel a great deal. As far as I knew, we had a fine working relationship, and I had no reason to believe that anything changed. I think I in this situation have been more patient, respectful, and understanding of this defense counsel than I would have been with a lot of other counsel for that reason, because we started out respecting each other. Obviously, we've hit a point where that's changed. I'm not sure exactly why, and maybe counsel will enlighten us today, but he seems to have a personal problem. I am perfectly fine arguing law. I'm perfectly fine arguing procedure. I am not fine with personal attacks. Those personal attacks are not just in the written form in these public filings where I'm being accused of all kinds of things. They've also been verbal. They've also been contained in an email communication. I have an email, and quite frankly, Your Honor, I wasn't going to bring this up because I don't take personal offense. This field makes us develop very thick skin, and I don't anticipate in dealing with other people within this field for them to have thinner skin than I do. And perhaps that is my mistake, and I need to be more cautious and aware of people's hurt feelings and how it affects how they conduct themselves. I do want to put this on the record because I think it speaks to why we saw the reply that we saw. This is an email from September 25th of this year from Mr. Doust to myself. It's in response to a request he made, a reply I sent him. Which again, we can certainly look at that, but this is the part I'm concerned about. Curious, you can articulate and posture all you want, Marie. Just don't think for a second that I'm not seeing right through you. I don't know what the intent of that email was. What I do know, it's not necessary for what was being discussed. What I know is that it's a personal attack. So I'll just leave it at that.
That email. Don't think for a second I'm not seeing right through you. That's the spark that ignited this fire. In courtroom culture, that's not just unprofessional. It's dangerous. It suggests personal animus, which can undermine a defense attorney's credibility with the court. The prosecutor wisely reads it without emotion, letting the words condemn themselves. This is more than workplace hostility. It's evidence of bias. And when she connects it to gender, and boom, the whole narrative shifts. The judge now has to balance fairness with discipline. What would you have done after receiving that message? Ignore it or go public like she did?
I've read over the years a number of your pleadings, both from you and both from those in your office. I'm trying to be careful in the way that I put this. What I read when I received that, I was surprised. Surprised, and I will say a little bit taken aback. Mainly because, and you know me, I'll just be blunt, I expected better from you. So, and I say that not with any thought as to how I would rule on this issue, because that wasn't really what was playing into my mind. Just expected better. Go ahead, Mr. Doss.
Thank you. This is not personal, Judge. This is professional.
Which part?
What I have put in writing and submitted to the court.
No, Mr. Doss. And I'll let you go on. But no, this was clearly personal. I have been reading briefs and preparing briefs, memorandums for over 30 some odd years. I've been reading them as a judge for over a quarter century. If I say to an attorney that I'm taken back by what you put in and that I expected better, you can take that however you will. You can defend yourself. You can say I'm all wrong, that I'm washed up, that somehow or another you can say whatever you want. But I don't say it unless I mean it.
Understood.
Go ahead.
Well, I'm an honest man. Ms. Tanner is quite skilled at doing one thing and then portraying it as something else. On September 23rd in chambers with Judge Bauer, she brought up a legal issue for which there is no support.
This is a remarkable segment. The prosecutor brings the issue full circle. She accuses the defense of sexism again, but now backed by context and evidence. This is rare in open court. She's making a stand not just for herself, but for female attorneys everywhere. Notice her phrasing. I highly doubt any of my male colleagues would be treated this way. That's not anger. That's indictment. It forces everyone listening to examine their own biases. She even gives the defense an off-ramp. Withdraw. Paragraph 5 from the filing, showing she still wants a professional resolution. Smart move, assertive but not vindictive.
Authority. We sought to have a conversation about that, and there was no conversation to be had with Ms. Tanner. And so the exam ended up being adjourned because Judge Bauer at the moment was not in a position to decide any of this. The legal issue before the court is, there's no dispute that preliminary examinations are governed by statutes, court rules, and the Michigan Rules of Evidence. And under those rules, under MRE 4482C, defense counsel at exam at a CSC case may inquire about what is permitted within those rules. The proposition before the court is raised at the last occasion is that for defense counsel to elicit evidence under that rule at exam, there first has to be a motion and offer of proof. For that proposition, there's no authority whatsoever.
Okay, Mr. Doss, can I just stop you since you want to get into the substance of it? Let me just say this. All the years I've been sitting on the bench, the rape shield statute has applied at preliminary examination. Because if it didn't, it frankly makes no sense. To say to someone, we afford you these protections from this intrusion into your life here, but we don't do it here, makes no sense. Because it's one of those things that once the cow has left the field, it's out. It's just there.
Now the defense responds, and instantly we see his strategy: deny it's personal. But by doing so, he reinforces the prosecutor's point. Notice how he deflects to technicalities, statutes, rules, case law, without addressing tone or behavior. Classic damage control, yet the substance of his argument matters. He claims the rape shield rule doesn't apply at a preliminary exam. That's a risky stance. Why? Because if he's wrong, he's not just mistaken. He's challenging settled practice and potentially re-traumatizing victims by allowing invasive questions too early.
And so it doesn't make any sense. Moreover, Mr. Das, I was a bit surprised by it because your colleague, Mr. Shea, has argued the rape shield at preliminary examination, I believe on 2 occasions, but certainly one before me, and never indicated, never said whatsoever that it does not apply at preliminary examination. Go ahead.
Well, the authority that there is on that issue is to the contrary. I believe it, I put it in writing. I provided the court with the authority. What in fact I did was, I did not submit an advocacy piece. I did not, I'm not asking anything of the court. I'm not trying to convince the court of anything. I advised the court on what the law is. I believe I was well within the rules on going about it in that way. As far as now what Ms. Tanner put on the record earlier, I understood, based on what the law is, that Ms. Tanner on September 23rd was taking an unsupported legal position and was in a way misinforming Judge Barr about it and was not having a conversation about it.
What, misinforming Judge Barr that the rape shield applied at preliminary examination?
Yes.
She would be taking a position that has been the longstanding practice in this county. How can you say that she's somehow just come out of with something out of thin air? Show me one case, Mr. Dawson, in this county where rape shield has not been applied and not stood at preliminary examination.
The aspect that doesn't apply is the mechanism of a motion and offer of proof in MCL 750520J2. That aspect is just not applicable at this stage. It comes into play once the case is bound over. And that's the very issue that Ms. Tanner raised. She approached me asking whether I would elicit any testimony.
So, Mr. Das, you paint yourself into a corner. Because if that's the argument, then none of it comes out at prelim. Because the judge at prelim is the gatekeeper of all of that. And so what would actually end up happening is none of it would come in, ever. And then you go ahead and just make your argument in, circuit court.
Well, I understand we disagree on what the applicable...
His part is legal gold. The judge dismantles the defense's position piece by piece. He points out the logical absurdity that without the rape shield at prelim, sensitive evidence could be aired publicly with no remedy. Once that cow leaves the barn, as he puts it, privacy is gone forever. That line perfectly captures the stakes. For the audience, this isn't just legal technicality. It's about whether victims' protection applies before trial. And here the judge makes it clear, yes, it does. You can practically hear the gavel of authority in his reasoning.
Law is on the issue. I did put it in writing. It is published.
But I'm talking about two different things, Mr. Doss. I'm saying if you're indicating that the doctrine of rape shield and the protections that it's afford do not apply at prelim, then the judge, quite frankly, has the option of not hearing that testimony. Plain and simple. And then I just don't let it in. If I'm handling it, I don't let it in. And then you're going to have to deal with it as you want to deal with it in circuit court, which you won't get it in there.
If what the court describes were so, then the court would at that moment disallow the admission of relevant evidence under the court rules.
It's irrelevant. Somebody's past sexual history is irrelevant. I could just say that and I'm done.
Not with the defendant.
Pardon?
That's what the law says. That's what the court rule says, not with the defendant. That is not what the rule is. So if I can go back once more. The very core item that's at issue is whether defense counsel before exam needs to provide a written motion and offer of proof if defense counsel wishes to inquire into evidence under 404A2C. And the law on that is that no, defense counsel is not required to do that. Defense counsel may inquire under the rule.
Okay.
Okay.
And if the judge says, I need a motion before you do it, what do you then answer?
I would ask the judge, what is the legal basis for making that requirement?
And the judge is going to say, because I said so.
I am hearing that, and yes, I am greatly at odds with it because there's no legal basis.
Maybe that's the
for that
reason
requirement.
you wear the robe and you don't.
All right. I did submit in writing what I know the law to be, and I stand by that.
Anything additional, Mr.
At this point, Your Honor.
All right, this court is ready to rule so that there's an order that Fashion Judge Barr can deal with. And that is that this court indeed does believe that the rape shield statutes were intended to offer certain protections to potential victims. That evidence, and this specifically needs to be noted, that evidence shall not be elicited at preliminary examination in any greater or lesser fashion, but in the same manner as that evidence would be alluded to at trial. To do otherwise would make the rape shield a nullity in its entirety. And so therefore, that evidence will not be allowed until such time as the court has had an opportunity to see what evidence is proffered at preliminary examination, is going to be proffered at preliminary examination. Tanner, you will prepare the order. I will sign off, and that is the ruling of the court. Is there anything additional?
When the defense keeps arguing, the judge uses sharp Socratic questioning to corner him. What if the judge says, "Because I said so"? That's not arrogance. It's judicial hierarchy in action. Once a ruling is made, an attorney's only recourse is appeal, not debate. The judge even reminds him of that power dynamic. You wear the robe, you don't. It's the courtroom equivalent of checkmate. And here's the takeaway. Even experienced lawyers sometimes forget that knowing the law isn't enough. Knowing when to stop talking is an art form,